Will Donald Trump be sentenced on the 10th of January, as Judge Merchan has outlined, or will an appellate court bail him out? We're going to know sooner rather than later, because Donald Trump and his lawyers, soon to be part of the Department of Justice, Emile Beauvais and Todd Blanche, have just filed a notice of automatic stay, a motion to stay the sentencing while they pursue their appeal, claiming that they have automatic rights to a stay because they've raised the I word, immunity, even though they've raised it incorrectly, post-conviction and pre-sentencing. I'm Michael Popok. I'll break it all down for you. By the time you're done with this hot take on the MeidasTouch Network, you will understand what's going on and my honest opinion about what should happen next. Let's pick it up with the filing. We just got the filing today, and they're claiming, I'm sure they're working round the clock on some sort of appellate brief as we anticipated. Last week, Judge Merchan shocked many of us because in the one hand, he properly denied a motion to dismiss on immunity grounds or on justice grounds that they had filed. Trump's side, we call that a Clayton motion in New York. There's 9 or 10 factors of the Clayton motion, and they didn't satisfy any of them, and the judge rejected it. At the same time, the judge announced to the world that he would go forward with sentencing, as I had hoped, before the inauguration on the 10th of January, and that he was inclined, as of right now, not to impose any jail sentence. And we did a lot of hot takes about whether he should or he shouldn't, and what the Manhattan DA should or shouldn't do on appeal to try to get an appellate court to sentence him to jail. Now, as expected, he's appealed. He's about to appeal. This is sort of a pre-appeal paperwork that's been now filed with the trial judge, Judge Merchan. And I'll read to you from certain aspects of it, but let me summarize it for you. They're basically saying that under two different court precedents at the United States Supreme Court, including the Trump v. United States immunity decision from last summer, that they have the automatic entitlement to a stay, but while they pursue an argument that some sort of presidential immunity prevented the conviction and hence the sentencing, even though 99.9% of the facts or the narrative and timeline about the 34-count felony conviction in New York against Donald Trump and the Stormy Daniels conspiracy had to do with him not being president of the United States at all. In fact, it was a conspiracy, as proven to the jury, of 12 people to interfere with him, the election process against Hillary Clinton, which ultimately got him the presidency. There was a very small amount of evidence that was presented to the jury about what happened to the conspiracy petering out, being paid out by Donald Trump when he already obtained the object of the conspiracy. He became president. You know, some checks he wrote to Michael Cohen, a couple of meetings he scheduled with his staff, a couple of comments made by the press secretary at the time. But that's not the heart of the conspiracy or the evidence against Donald Trump, and therefore and shouldn't be found to violate the Supreme Court's position about immunity about a sitting president, because he wasn't a sitting president during the heart of the conspiracy. But to Donald Trump's lawyers, he enjoys president-elect immunity. There's really no such thing. He enjoys presidential immunity from any criminal process. Well, we're only at the point of the criminal process where it's now the sentencing part, and the judge has already said he's not going to put him in jail. So how does that impair or impede the office of the presidency? That's all that matters in the separation of powers argument by the United States Supreme Court. In their first argument, they say, let me just read to you from their opening here, and then I'll read to you from some attacks by Stephen Chung, the incoming communications director for Donald Trump. It says, President Trump hereby provides notice to the court and to the prosecutors that he will be filing and initiating an appellate proceeding on January 6, 2025 to challenge the ruling about immunity and the like. They then go on to say that, as discussed herein, the commencement of appellate proceedings, which should result in a dismissal of this politically motivated prosecution that was flawed from the very beginning, centered around the wrongful actions and false claims of disgraced, disbarred, serial liar, former attorney that would be Michael Cohen, violated President Trump's due process rights and has no merit, seeking interlocutory review, this is a long-winded sentence here, of these claims of presidential immunity immediately results in an automatic stay of proceedings in this court under Trump versus the United States. They also go on to cite, listen to this, they cite to a decision by the D.C. Court of Appeals concerning Judge Chutkan's case, in which the D.C. Court of Appeals ruled that they should have that he was entitled to an automatic stay once immunity was raised. But that was immunity from the very prosecution, not this period of time that we've never had before in our history, where a candidate for president is convicted of actions about him being a candidate for president, not president, but then after that, and before he is sentenced, after conviction, when he's not president, he was convicted before he was president again, but now before sentencing, he's a president again or president-elect. This is unique and troubling times we're under here. There's no case law that addresses a criminal presidential candidate, and this thing gets stretched out so that the conviction is before he's president, but the sentencing is after he's president-elect. That's never happened. And they don't really cite a lot of case law in this area because we've never had a criminal president or presidential candidate before, and so we're in uncharted waters here. They then go and misapply the Trump versus U.S. Immunity decision. That did not address what happens in this weirdo period where a candidate is then convicted while he's still a candidate, but the sentencing is going to be after he's elected again. It dealt with what happens and what you can do about presidential conduct, official conduct, unofficial conduct, private conduct for the guy that's the president, and what you can do and whether you can prosecute that while he's in office or not, or whether he enjoys some sort of temporary immunity or absolute immunity. That's what that case was about. Not what happens to whether you can sentence him on the 10th of January after the jury convicted him while he wasn't president yet. See, Donald Trump wants the world to believe, under our constitutional concepts, that because he was lucky enough, fortunate enough to somehow win the presidency again, that is like some sort of giant Etch-a-Sketch, and you just shake it, and it erases all of his culpability and all of his misconduct, all of his convictions, and all of the charges against him. It doesn't. One of the single biggest predictors of how long you live and how good you feel while living is your metabolic health. Now, I strongly believe that you can't manage what you don't measure, and metabolic health can be difficult to measure. This is why I use levels to track my daily health metrics and habits and ultimately optimize my metabolic health. Levels helps me understand how my food and lifestyle decisions are impacting my health. In the short term, I use levels to optimize my energy levels during the day and manage weight. In the long term, I'm thinking about the many chronic diseases that are directly linked to metabolic health, including diabetes, heart disease, and Alzheimer's. I use levels with a continuous glucose monitor to get my own personalized data, which I've found to be really powerful to understand my own unique physiology. But you can also now use levels without a continuous glucose monitor. I never realized how much a simple pizza could really spike my glucose until I started using levels. Levels provides me with powerful, real-time, personalized information on how my body responds to different foods and activities. Having access to this data is a critical step to making better choices that will, over time, have a huge effect. Levels has recently launched some exciting new features to help you track your macros: protein, fiber, fat, carbohydrates, and sugar, and to create daily habits around your health goals. They also provide insights based on trends in your health metrics to help guide you to make decisions that will have a positive impact on your health. Metabolic health is about glucose and much more, and Levels now helps you keep track of it all. Now is a great time to get started if you've been waiting for the right time to join Levels to improve your metabolic health. Right now, Levels is offering my listeners an additional 2 free months of the Levels annual membership when you use my link levels.link/legalaf. I don't know how long this offer will last. So if you've been interested in learning more about your metabolic health, now is the time to get started. I mean, at the very least, it's temporary immunity for certain aspects of cases against him and continued prosecutions against him. But this prosecution is complete. The conviction is obtained. The jury has spoken. 34 felony count conviction has spoken. Now we're just down to the sentencing, and the judge has already tipped his hand and says he's not going to send him to jail anyway. I may disagree with that, which I do, but that doesn't have anything to do with here. Now, they go through about 12 or 14 pages, and they're fun, but it's the same argument over and over again, that the presidential immunity enjoyed by Donald Trump nullifies the power of this trial court to act. That's it in a nutshell. I mean, it's repeated 17 different ways on 17 different pages, but that is the summary of it. And that the stay is appropriate because it gives time for the appellate process. Now, that's a different argument. Whether the appellate court, because they're going to have to file it not at the Court of Appeals, the highest court in New York, but they're going to have to file it at the Appellate Division First Department in Manhattan. And whether that court believes that they should stay the sentence, not for immunity grounds, so that they can be fully briefed, so that it can be fully briefed before them on all of the issues about the trial judge and the facts and the case and all of that, whether they want time to review and evaluate that on full briefing, so they want to put a pin and hold the ring in the sentencing schedule for the 10th, that's a different story. That could happen. That could happen. We could have a stay. We've seen it before, maybe a temporary stay. Or they may say, go through with the sentencing. That concludes, you're not even president yet in the 10th. That concludes the entire criminal process. You will have the sentence, and then from there, with the sentence and the judgment of conviction, then you can take your full appeal, so it's not piecemeal. Donald Trump's trying to argue for what's called an interlocutory appeal, when it's not quite done yet, but before it's even concluded, I get the right to appeal. And in certain circumstances, you do, but not these. If I'm the appellate department first division, if I'm the first department, which is that intermediary appellate court, I deny the stay. I put the appeal on a full panel, on a full schedule, tell him to do the appeal after he is sentenced so that the appellate court can address all of the issues all at one time, that they don't find immunity is really the thing that's driving the appeal here because of the timeline of when it happened and what happened and Donald Trump's status at any given moment in that timeline. And they go, yeah, we'll take a full appeal from you at that time. And maybe... And they'll say there's nothing to stay because if the judge, by the way, they may want to say, let's wait to see, as an appellate court, let's wait to see what the trial judge does. Because if the trial judge does what he says he's going to do, which he's not going to impose a jail sentence, he's going to do an unconditional discharge. Felony stays on the books, but unconditional discharge, we got plenty of time to do the appeal. Because we're not looking at Donald Trump's liberty interest being compromised. That's where I think they end up with this. But, this will get a lot of press. Of course, you've got, here's the quote from Stephen Chung, just to show you, they're continuing, of course, to politicize all this. Today, President Trump's legal team, these are the same guys who are going to be the number 2 and number 3 in the Department of Justice in about a month's time. He's going to have to find a new legal team to continue with these matters because they're going to be in the Department of Justice. Donald Trump's legal team moved to stop the unlawful sentencing in the Manhattan DA's witch hunt. I mean, look, don't do the crime if you can't do the time, as the famous philosopher Barreto once said. The Supreme Court's historic decision on immunity, he's talking about the trial level court. He's talking about the U.S. Supreme Court. The U.S. Supreme Court's historic decision on immunity, the state constitution of New York, okay, I know that better than Stephen Chung, and other established legal precedents mandate that this meritless hoax be immediately dismissed. Not happening. Here's what I think is going to happen. Let me end the hot take this way. Here's what I think is going to happen. You're going to have the Appellate Division First Department get the papers on appeal. I think they're going to not stay interlocutorily stay the sentencing on the 10th. They're going to let the 10th go forward. They may even just sit on their hands and just let it happen. They don't have to rule on these papers. They can just let another 4 or 5 days burn off. Now the sentencing has happened. Donald Trump doesn't like it. He can go try to run to the U.S. Supreme Court for some sort of stay, but he's got to, on an emergency application, he's going to have to go through Sonia Sotomayor, and I don't see it happening. So I think the 10th is going to happen. I've been wrong before. I just don't think so here. They sit on their hands if I'm the Appellate Division, First Department. They let the 10th happen. Then they let him take a full appeal. Now that he's got sentenced to no jail time on a normal schedule, he goes into the presidency on the 20th. He gets new lawyers because he's going to lose these guys, Beauvais and Blanche and all that. And they prosecute the appeal. Win or lose, thumbs up or thumbs down. May take 6 months, may take 5 months. They don't like the results. They can try to do something with the U.S. Supreme Court. I'm not sure the U.S. Supreme Court necessarily bails him out on immunity grounds for this particular thing. They didn't bail him out. Let me just tell you where I'm coming from. They did not bail out Donald Trump. And it doesn't look like they're going to, on the E. Jean Carroll $100 million of judgments, where he had a claim, even though I think that was phony too, of immunity for having sexually assaulted her and then defamed her when he was inside the office and outside the office of the presidency. They've been sitting on the sidelines and they have not intervened in that civil case. Now, this has criminal implications and justice and all of that. But frankly, liberty is not at stake if Merchan goes forward with his plan to discharge him unconditionally without a jail sentence. So that takes away the whole impairment and impeding of the presidency, because it's just papers now being shuffled around by lawyers, like me, and oral arguments. I'll continue to follow it. You're on Legal AF and the MeidasTouch Network. We do this here at the intersection of law and politics about every hour, and it's going to get hot and heavy come the inauguration and all the executive orders. Tune in here, that hot corner of law and politics. You're going to want to come back to us time and time again on Legal AF. New channel on YouTube. Help us get to 500,000 free subscribers in less than 6 months of our existence. That's all on you. We appreciate you. I curate that channel. And then, of course, Legal AF, the podcast. So until my next reporting, I'm Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.